So when everybody has taken her seat, we might start with the presentation of somebody who is first unrepresentable because he is so unique that he could never be replaced by whatever. So the question of how somebody to double you could be invented is a contradiction in itself. We heard Upendra last time, this Saturday, during the Weber conference. Those who had been at Duisburg for the opening of a new Käte Hamburger Kollegs dealing with global cooperation could listen to him this morning at 11 o'clock. Then in the afternoon he's speaking at our Center for Advanced Study Law as Culture. That means you are somebody who is everywhere, and this is a little bit guru-like indeed, because most of us would not be able to do that. So it's an enormous pleasure to present you and with the topic you will discuss with us this evening. Most of you know Professor Baxi as one in the first line of international legal theorists, especially with regard to human rights, with a background in Indian philosophy, in Indian legal thinking, legal thought, and a background also in the European Occidental world in the same time, and all this comes together in a global direction, and with a strong emphasis on diversity, perhaps not diversity management, you would refuse this kind of wording, but on the other hand, to deal with diversity on a basis of very universalistic values, especially in your understanding of the human rights. Your publishing, the way you publish is really incredible. It is not the amount just of books, more than 20 books yet that you authored, and more than 200, 300 articles, and even during the time you are here with us as a fellow, the list goes and grows longer and longer, and we admire you for this and for a lot of other things. Especially also, I would say, for not being only a human rights theorist. You must know, in order to understand what Upendra Baxi is doing, he is also an activist. Activist born in the same city as a certain Gandhi. You might have heard this name in your youth, and you went to the same school. So there is a certain tradition, and as you might have seen on the first floor in our Ambedkar room, Ambedkar is who worked together with Gandhi, is also well known and recognized because he was, among others, a student of our University of Bonn. So there are very strong links between Bonn, Germany, and India. You know that we have a German-Indian year that comes to an end in an Indian summer, as we would say in the United States. So, I would like to come back concerning the content to the main topic of the last month of this year. It is about globalization and law. You remember that 2 or 3 weeks ago, I don't know anymore, we had an evening together with Rudolf Stichweh and some introductory remarks from my side that dealt with the question how to conceive legality, normativity, normative orders, law of and in the world society. That was the question we raised. From the background of conceiving globality at all, what is a specific problem conceptually, theoretically, practically, empirically, and so forth, a huge problem. A problem that was served to us by Martin. Where he is? Martin. Yes, there he is. Martin Albro and his friends, Tony Giddens and Robertson and others. So, excuse me, but you're responsible for that, and so that's why you will speak next week, and you have to justify what you have done to the world by your global semantics. But in the context of legal reasoning, it is especially important to do that in a serious way, and it has enormous consequences. And last time we discussed the consequences for international economic law. We discussed at least some consequences for family law in a European framework, as Ms. Dedloff will discuss it with us during her year and her time as fellow at our Center for Advanced Study. And the human rights question is something that is very, very central to this problematic. So, the topic of today, if I understand right, you will explain, but let me try to understand just from the sovereign debt, human rights, and global impoverishment. It starts with debt. So we would call it, we would say in German, Schulden, Verschuldung, Staatsverschuldung. And this has in German a very strong moral undertone. It has to, and even Verbindlichkeit is something that switched from philosophy over religious contexts. It has a religious connotation, then to the economic sphere lately, and finally to Verbindlichkeiten that becomes completely unverbindlich. So you see there is a shift even from a religious and a moral grounding of debts to something that becomes very mundane and very much secular. It has a sacred religion and sacred background. So what does it do to human rights and especially the state finance crisis that we have worldwide? Is the fact that so many people, and I'm not talking about the very, very poor, I'm just talking about people who had their house and home and homes in the United States of America, in Spain, in Italy, and so forth, and who were really very heavily hurt, having always felt secure in their life, a bourgeois life, but bourgeois lives that were destroyed, and other lives even much more. What does it mean? Is there a human right implication in all that? So that's my question. But perhaps you have a completely different talk, and so at least this is something I would like to know, and other things of the whole context from the specialist, I think, who is able to give us answers to this relationship of finance crisis, human rights questions, and impoverishment that has to do with the process, the very opaque and very ambiguous process of globalization. So thank you very much for being with us and sharing with us your incredible knowledge. Thank you.
Thank you, dear Werner, dear friends and colleagues, for turning up in the shadow of a minor born reproduction of the storm Sandy elsewhere, when inclement weather, even in Bonn. And thank you for your act of solidary presence this evening. It has been a chaotic day for me, and it has been a creatively chaotic past 3-4 days with our various ways of cohabitation with a figure called Max-Weber. So all of us are very tired, and we have a human right to be tired, or to moral fatigue, or whatever. I'm a little more tired because I had, as Werner mentioned, an additional responsibility to speak about something called international cooperation at a new Hamburger college in Duisburg. And it was something that was noble, act of cooperation. But on return at Bonn railway station, my wife had a peculiar experience of what early socialists called redistribution of property and what modern European law calls theft. And there was a traumatic moment for her because she lost not just cash but credit cards and so on. It was equally a traumatic moment for me because I couldn't really be with her. I should have been. But I had to do justice to your presence. So I sort of tried to make sure that on such an important topic I'm little less incoherent than I usually am. So, Werner, I might have an assignation with the German police tomorrow, which conflicts with the prior engagement of the fellows' meeting. Yeah. If I can persuade the police to come and join the fellows' meeting, I'll translate. But should that not happen, my advance apologies for this inadvertent absence. All of you spend a long day, and to think for the moment of a great work by Jacques Rancière, who wrote about narratives of laboring men and women in France. His book was called Long Nights of Labor. I've had many long nights of Weber because I had to present some kind of paper, which I did. So now let me come to the topic of today. Why this crazy trinity of terms: sovereign debt, human rights, and impoverishment? Well, you may ask, and well may I not fully answer, by the way. Why this crazy thing? Well, for one reason, I'm simply bored and sick and tired of this G word. That's globalization. You know, it's a word that means everything to everybody and nothing to thousands of suffering people. So I think we have to cut. Well, I'm a vegetarian, so forgive me this expression, cutting closer to the bone. I think you do it with the beef or turkey. I don't know what you do with it. I only make chutney and there are no bones in the coriander. Anyway, cutting closer to the bone, I think it's the question of the G. I think if we cannot dispense with the G word, then at least we must try to understand it differently. And Martin Albro, in a superb performance, an autobiographical narrative, told us that doing things with G words have biographical impacts as well. I will not go there. I simply would say that, and I look forward to your speech next Tuesday as a continuation of this conversation. I think we have to discipline our use of the G word. And there are several ways of doing it, and many people have done it. In my view, the G word can be disciplined in terms of financial and economic globalization. Financial, monetary, economic globalization. And nothing to do with this silly thing called, forgive me, called global governance. And nothing to do with cultural globalization and so on, political globalization. And I don't understand whether you can speak of this kind and that kind and that kind of globalization as if these are, you know, we had a marvelous story, and I shouldn't say it because it hurts my eyes, of elephant and 9 blind men of Hindustan, and each person who couldn't see the elephant thought that the leg was the elephant, whole of elephant, and the trunk was the whole of elephant, the tusk was all of the elephants. So I think this metaphor of 9 blind men, or we should now say visually disabled, Hindustan, is the narrative, is the story of our relation with this elephant called globalization. So one would like to perform some surgery on our eyes. I had a constant problem for last 3 years with my eye doctor because I had retinal detachment, to be personal, and it had a long 3 surgical molestations of my left eye. It has to be left because everything left is in comprehensive trouble. So it was the left eye, not the right eye. And he always used to say, Professor Baxi, I don't know why he called me that way, he said, I shall surely do justice to your problem of vision. And I used to say to Dr. Schroff, his name is Dr. Schroff, a leading world eye surgeon, I said, I resent your remark. I have nothing wrong with my vision. It is my sight that's the problem. So when you consider globalization, the G word, we have to use acute visual metaphors. Are we talking about failure of the sight or collapse of the vision? All right, I'll not indulge in further metaphorical foreplay and get down to, as the Americans say, brass tacks, which is, I think, a sexist word, so I apologize for that. I think, and I must be careful because I don't want to take your time for granted.
There is a nice watch over there, you see?
Yeah, but it's already said it already said 1 hour and 20 minutes late. So thank you very much and goodbye. No, fine, fair enough, fair enough. I'll be about 20, 30 minutes at the most. But let me try to. I think the main import of globalization, if you must use that word, is its techniques and formations of what I call disciplinary globalization and regulatory globalization. And the notion of disciplinary globalization, which some of us neo-Gramscians have developed, and Gramsci is not considered seriously by Weberians. Another conference in the Offing-Werner, relation between Gramsci and Weber. Anyway, we think of globalization in these 2 domains as signifying different formations of hegemony. And those who know Gramsci would, I want to carry MIC to Bhopal victims. I don't have to explain to you what Gramsci meant. But it is a formation in which a vanguard bloc emerges which provides moral leadership to the rest of the people, creates grounds for consent, manufactures consent, and negotiates coercion as legitimate. And in our case, this is the Washington Consensus and all that follows. From Washington Consensus to neoliberalism is a Gramscian story. It might also be a Weberian story, but I'm not going to go there. So what does disciplinary globalization mean? This is exactly in one sentence, one phrase, what we see in the Eurozone crisis. Sovereignties don't exist. Faceless bureaucrats, anonymous bureaucrats decide what popularly elected governments must here and now do without a trace of accountability in law or in terms of moral responsibility. It's a strong statement, and if I have time, I'll come to that. Now, Weber did not imagine a bureaucracy. He only thought of bureaucracy. But I'm not going to Weber today. I'm preoccupied with the last 3 days. Forgive me, don't let me go there. And throw something at me if I mention Weber again, because it's not the time to do that. I got to get back to this theme. So disciplinary globalization is imposition of conditionalities for financial, monetary, and fiscal bailouts by some privileged countries, not merely in Eurozone, over other less privileged countries or societies or peoples. You can go back to Foucault, discipline and punish, and you can also think of disciplinary globalization that way. And regulatory globalization is another important phrase which I can't develop here, or transactional globalization, which is manifest in the WTO, the international financial institution, the regional banks, supranational EU banks, and so on. To me, therefore, for the present purpose, and really, as far as my thinking goes, every time, the G word is equals DG and RG, disciplinary globalization and regulatory globalization. It is in that sense that if I use G word, it is this sense which I don't use the word global governance, because I don't think the element of governance is immediately in contemplation in these processes. Now, why do I talk about why do I talk about human rights, sovereign debt, and global impoverishment? First, because the G word stands for aggravated global, worldwide inequalities and inequities. That's what globalization is all about. Some people have more than 2.5 times the lifetime, whereas others die early. Half the children born in the global south die before 5 years of age. And there are many statistics which 800 billion people die of preventable starvation. These are, devil can quote from scriptures, so I quote from World Bank figures. So you have got a world which is divided into almost 2 or more planets. Some people are fortunate to live in a celestial planet of affluence. Other peoples are doomed to survive in the nether region of dire poverty. This is what globalization means as a lived reality. How does it come about? I have no time to go into that, so I'll make some coded remarks. Colonization, Cold War, heavy indebtedness of the new post-Westphalian nations, structural adjustment programs, and now that terrible neologism called neoliberalism. So there is a whole complex of conditions, each with a separate history, which not merely perpetuates severe global distributive inequalities, but constitutes dire conditions of poverty. Right? I'm not going to talk about the causation. I'm going to talk about the consequences of this fact. And one of the obvious consequences, as I already mentioned, is that we live in a world marked by conditions of 2 kinds of global poverty. One is called EP, condition of extreme poverty, which means less than PPR, purchasing power or something, PPR, $1.25 a month. That's the condition in which you live. What you pay for coffee here, yeah? That's the conditions of extreme poverty. And there are conditions of global poverty, which is different from extreme poverty. Why is it different? It's different because on all accounts, in the 21st century, conditions of extreme poverty constitute a moral scandal which ought to shock the conscience of humankind. And they are entirely eliminable. It would cost not more than a few $100 billion to make sure that infant mortality goes down, that starving millions numbers go down, that children below the age of 5 do not die prematurely, etc., etc. I don't, to make a terminological clarification, use the word poverty at all. Ever since 1989, in a book I edited called Law and Poverty, I have insisted that the appropriate term is impoverishment and not poverty. And I'll explain this in a minute. If you use the word, and languages are very important, if you use the word poverty, you do not talk about human rights. You talk about charity or caritas. Our Lord Jesus said famously, didn't he, somewhere, that the poor shall always be with us. He also said something which will be a non sequitur, but he did say it with great respect, that the meek shall inherit the earth. How many millennia would that require? Only our Lord Jesus knew, and I'm not a student of Jesus. I think the language of poverty glorify the condition of poverty, and that's why I don't use it. How do they glorify? One, by the notion of caritas, that poor should be subject, poor are subject to our compassion. And compassion is a Christian or a global spiritual virtue. It's a caritas, a gift of God's grace to humans. And to perform charitable acts is to render service to the Creator. Nothing wrong with that. The way I'm putting it is short, but I don't mean to disrespect the idea of charity. In modern times, the notion of caritas, as you all know, has been transformed by particularly the feminist thinkers, starting from Carol Gilligan or early Simone de Beauvoir and the Ethics of Ambiguity, to Susanna Sherry, Judith Butler, and Martha Nussbaum, for example. The feminist thinkers have tell us that what is important is not charity or caritas, but the underlying ethic, and the ethic is the ethic of care. And the ethic of care, they say, women thinkers tell us very importantly, must be distinguished from the ethic of rights, because rights are competitive, legalistic, atomizing, etc., etc., whereas care implies a community of concerns. I will not go and elaborate that anymore because I don't have the time. Werner Gebhardt often mentions to us, and quite rightly, about the fact that globalization in Lady Dying creates a community of global care, grief. But Werner, I was in Delhi from Warwick, And I watched, like millions of people, Lady Di's funeral procession. The very day Lady Di died, so did a person called Mother Teresa. In the 24/7 global media had no time to grieve for her passing. So there are problems. I'm just trying to be telegraphical here in mentioning this content. I'm not criticizing your point of view. I'm only saying that any community of grief decelebrates the other, does not speak to the other, equally important. And how do we read this cultural globalization is a matter which I leave to the master, that is Werner Gebhardt. For me, the important point is that in the language, which I will not address, we had a big problem and a big discussion and a big human rights movement called Jubilee, now Jubilee Plus, for debt cancellation of highly indebted countries. There are about 70 such countries in Asia, Africa, Pacific, Latin America. And the idea there was debt forgiveness. Now, who was forgiving whom? Who was forgiving whom? The European nations, who and their institutions, post-Westphalian included, were forgiving the interest on the loan that they provided to the ancestors of this poor, wretched of the earth people in so many. The expression is LDC. LDC, MI, middle income developing groups. You just look at the UN, and you have to cease to be a human being, because the way it spawns acronyms, LDC, LI, whatever. I get very upset about it. I won't share my grievance now. It's not the time. But whenever you read these words, see what is the mentality in the French way, history of mentality that is involved. You have to forgive these poor people. But how do you forgive them? Today, X number of countries have been forgiven their debt, but what they have been forgiven is not the original debt. What they have been forgiven is the interest repayment. So generations of human beings in the global south are still paying, are not defaulting on the capital debt, they're defaulting on the interest. And in the recent 2012 article, William Easterly, a great political thinker, has shown to us that this debt forgiveness in fact aggravates the condition of the original debt. I will not have the time to go into that. So I'm begging you to think first about contrasting languages, poverty and impoverishment, charity and rights. You may come to your own conclusions, but you already perhaps guess where I stand. Well, impoverishment, just one single word, using Durkheim's idea of elementary social fact, I say impoverishment on a mass scale is a global elementary social fact, not just a social fact within nation-bound society. And I say to you that, in my view, impoverishment is a process by which certain privileged decision makers make other less privileged people live in conditions of poverty, low income, destitution. Therefore, impoverishment is a process of planned rational choice, often described in languages of development, international development, national development, what have you. Therefore, I think it's important to see what's going on when we talk of anti-poverty programs and sovereign debt. Now, let me now come straight away and abruptly to what I do not talk about today. I do not talk about, one, the debt relief programs, because this, I mentioned Professor Isserli's work, is a separate topic in itself, connected. I do not even go to another emerging area of my interest, that is sovereign fund problem. You know what sovereign fund is? What the OPEC nations, the Emirates, and some others, China, who as a collective entity in international law buy up properties and facilities, I'm putting it in generally, you know what sovereign fund is, in other developed countries. And I think it goes to the credit of President Nixon that they wouldn't allow Qatar or some such country to buy the New York airport and run it over. So when we talk about global governance, I think the question of sovereign funds by the resource-rich global South nations exercising control over the northern the states, it becomes a very important one. And again, I don't have the time to go into that. I will also not go into a more related area called the SAP. SAPs are structural adjustment programs, as you well know, imposed for more than 50 years by the World Bank and IMF on the poorest of the poor nations of the global South. Today in Europe, when same thing happens, it's a big issue. It was a big issue for peoples and scholars of the global South for the last 50 years. But we try very hard about Lois culture and global communication and solidarity. We live on different planets. IMF and World Bank said to country after country which had great problems of foreign exchange, of export, of balance of payments and so on, saying this is the bitter medicine. If you want our aid, we have to make people even more poor than you can imagine. I'm putting it in very broad lay term, but this is all so I'm not going into the past SAPs. I will speak to the present SAPs in Eurozone countries if I have the time. So let me now come straight away to sovereign debt. And here for the change I'm going to speak as an international lawyer, even in your presence, sir. But with a qualification as an extinct international lawyer, because I've moved on to Weber and other things. Although I'm told by geologists friends that extinct volcanoes are often more dangerous than the would-be live ones. I'll leave you to decide, my friend. So what is sovereign debt? There are two elementary notions. First is the notion of governmental borrowing by sovereign countries from other states. And we have now to add international and regional financial institutions. And from other sources now, such as banks, investment banks, bondholders, and so on. We know it since 2008 financial crisis anyway. So in the first place, sovereign debt is a contract relationship. And the contract is going to be a very important word for me, though I will not elaborate it. A relationship that involves a binding obligation to repay with interest the loan taken. I learned from my teacher from Yale and Berkeley, a Professor Frederick Kessler, who taught contract law and jurisprudence to us. Professor Kessler always used to tell us, and it's still live in my memory, that you have to understand the idea of contract and the jurisprudence of contract law in two metaphors. Contract is a principle of freedom. autonomy. Continentals will know this. Common law is a difficulty. Subjective rights or the freedom. Anyway. And it is at the same time a principle of order. So sovereign debts have to be read as containing both the elements, principle of freedom, principle of order. The second is the moral justification, moral idea of contract. If you made a promise, you ought to keep it. There are circumstances where you may not keep it, but on the whole, the idea is that those circumstances require severe justification. And the third is the Durkheimian notion, sociological notion of contract. I think what Durkheim Dada called non-contractual elements in contract. And this is going to play a large part in what I'm going to say later. So you got the philosophical notion of contract, got the moral notion of contract, and got a sociological understanding of contract. And I think you have to juggle these elements when you come to sovereign debt. Please. So, the first question is differentiation. Sovereign debt refers to two kinds of debts. One, state-to-state debt. And second, state debt owed to non-state actors, private parties, banks, investors, brokers, those who operate the market in debt. As far as I understand my international law, and you'll correct me, sir, again, I'm very glad for your presence today. As far as my reading up to 2008 goes, that's as far as it goes, the standard view is that the sovereign state does not, as a matter of international law, owe any obligation to non-state creditors, private banks and so on. It may be said to owe such debts, of course, in certain situations. Situation one, under the international law of responsibility to aliens, state responsibility to aliens. Situation two, when there are BITs, BITs, bilateral investment treaties. Situation three, where there is a customary obligation in international law requiring most favored nation or equal treatment of non-nationals. Sociologically speaking, this is not of much interest today after 2008 global financial crisis and the global governance, because the banks and the investment and the bonds market have begun to command attributes of sovereignty, superseding even the sovereignty of the United States of America. So, juristically speaking, it is clear that any state can repudiate debt contracts with non-state actors. Sociologically speaking, it's impossible, because the state is a surrogate of global capital. In fact, the state has ceased to exist as we earlier knew that notion. I quoted this morning Michel Foucault at Duisburg and expanded his notion. And Foucault, in his most graphic study of ordoliberalism or neoliberalism in Europe, particularly in Germany for 100 years, a massive study, says what neoliberalism ultimately means is two things. The state exists because of markets, and the state exists for the market. Period. So in that kind of situation, whatever international lawyers may think about whether these private debts can be cancelled is of no relevance. Or some relevance, but not particular relevance. All right. Now let me move on. Where do I go from there? Well, let me speak as a lawyer, international lawyer, for a change, and ask the first question. Is there a right to borrow state to state? Is there a right to incur sovereign debt? That's a very complex question. Summarily put here, it is agreed that a sovereign state has a right to borrow from other sovereign states. There are problems here. The first problem is, what is the source of this right? Where do you get this right from? And you go back to Grotius and Pupendorf and Vattel, or if you read non-European authors, which is a hazardous occupation, I realize, Kautilya, 3rd century BC, who also spoke about it. He is known as Indian Machiavelli, whereas it's the other way around, but I won't go there. But there is a lot of thinking on what is the source of this right. I will not go there. However, it's a curious thing that if you are going to say that a sovereign state has a right to borrow from other sovereign states, a curious thing happens in case of sovereign debt. Because the sovereign state which borrows, exercises its right, has a duty of repayment. But there's a more fundamental question. If I have, as India, I have a right to borrow from Germany, what sort of right is it? Is Germany bound to lend to me? We had a very brilliant American scholar called Wesley Newcomb Hofeldt, who transformed the science of jurisprudence. It's not known in the continent. In the continent, a chap called Kokoruck, K-O-K-O-R-E-U-C-K, is known, who also talked about jural relations. But Hofeldt used to say that the word right is heavily abused in legal discourse. Right means several types of jural relations. One is a strict sense, right and duty. If I have a right, somebody is a duty. You can't, it's nonsensical to say I have a right, but nobody has any duty. If you take that logic, obviously there is no right to sovereign debt. So what is that? Hofeldt. What a tongue of slip, Werner.
Not responsible for that.
Or did I say, slip of tongue? Another version. What will Dr. Freud say to me tonight? I don't know. Anyway, so Hofeldt said, there's another jural relationship of privilege, no right. You are privileged to ask me for a loan, but if I say no, no right of yours is violated. And that's the second kind of jural relationship that obtains. Here's the famous example. I offer you a salad, shrimp salad, which is of no interest to me as a vegetarian, but that was the example. And before you eat, I withdraw it from you. Is any right of yours violated? And Hofeldt's answer was no. It was a liberty relationship, not a right relationship. All right. There's also a further problem. If there is such a duty on the part of the other states to lend you money, how do we address the problem of sanctions? Trade sanctions. It goes so far back as Holmes-Burton law, 65 years today, US Senate, Congress passed it, non-trading with Cuba. It's the most astonishing law. It still persists, and EU has protested a number of times, and EU companies are merrily going along trading with Cuba, but they are in breach of this Holmes-Burton law. What about sanctions against South Africa, against Iraq, and now emerging sanctions against Iran? So that's a complex. I will not go any further. Let me move. The second question then, I'll just take 10-12 minutes more, if I may. What is this thing called state, which may borrow from other things called states? Now, one could say a state is a personification of collective human interests of its people. So there are occasions where the state can borrow in international markets, state to state, for a variety of good purposes, good reasons. For example, tiding over a monetary crisis, preventing inflation. You have borrowings of all kinds. Now some people say this kind of borrowing serves the purpose of fulfilling human rights. Because if you contain inflation by borrowing in market, poor people are less hurt who depend on this everyday price movement. Or if you borrow to buy oil and precious materials, so on. So there is a relationship between sovereign debt and fulfillment of human rights. That's an important relationship. There's a flip side. You can borrow from international markets or from other states without serving the people's manifest interests or needs. Thus arises, and that's my third point, the whole problem of what is called the problem of odious debt in international law. What am I doing? Better. Odious debt. Thank you. This is an old doctrine, and I will not have the time to explain, so here it is. It's a doctrine that was developed as early as by this chap, Professor Seck, in 1929, and which said this: if the state raises debt to service its own needs, to repress its population, this debt is odious for the population of the state. This debt, therefore, is not an obligation to the nation, it's a personal debt, etc. And therefore, its legality is open to question. And final kick: odious debts incurred and used for ends which, to the knowledge of the creditors, where so odious, create no obligations for repayment. Since 29, I give you another example. That thinking has developed further about the notion of odious debt. And I refer to Bajoni's comment of the International Law Commission. It says it's an ambiguous term, an umbrella term, but he also says that one problem is the problem for the successor state, what Ruti Tritel calls transitional societies. When states change, collapse, new states take their place, are the creditors entitled to recover debts from them? Now the first principle that Bajoni formulates is this: if it is contrary, manifestly contrary to the interests of the people, the successor state has no obligation of repayment. And this goes so far back from American US Constitution 14th Amendment, paragraph 4, which cancels the debt of the Confederacy regimes, till Iraq Commission on debts given to Shah by United States. And there's a lot of history. Unfortunately, I can only invite your attention to it. I can't go into details. But what Bajoni does, he was a great jurist, unrecognized, obviously because his location in the global production of knowledge. He's an outsider to the European International Law Club. And there are many outsiders. I won't give any further example, should I? All right. So, the second, he renovates the doctrine of odious debt. He says, now look at B. Any debt contracted for purposes not in conformity with contemporary international law and the principles and purposes of Charter. A third move now is An odious debt is one that ongoingly, massively, and flagrantly violates the human rights of peoples. So you got the odious debt in the first sense, as against broadly interests of the people, odious debt as violating of purposes and principles of charter, and odious debt as violative of human rights. How? I must end. I must move towards the end. I lost more to say. How will you speak to the Eurozone debt crisis in terms of any of the three versions of the doctrine of odious debt? Now, clearly, the first context is out. We are not talking about state succession, Greece or Turkey, would be Turkey, obviously that would be the same, Portugal, Spain. What I don't like that men, the Americans, I beg your pardon. I like everybody. As a human rights person, I like everybody. But who is that man who spoke about, Robert Kagan, who spoke about the old and the new Europe? Remember that? So Kagan, I don't like his analysis, I don't know him. He spoke about old versus new Europe. There is no question of state succession for the new Europe. They are old states. So the question is B. Have these Greek regimes, Italian regimes, Spanish regimes. Now, please be careful. I'm slipping already. We have to make a distinction between governments and states, or regimes and states. Only states are subjects of international law. Sorry for being so technical, but it's important. How were these debts incurred? What did they contribute to European politics generally, post-war, in the Cold War? How much European interests were identified with prevention of Soviet sphere of influence and therefore resulted in corrupt regimes which are now called corrupt in retrospect, but which were necessary for fashioning hegemonic Europe identity and interest. That is a big problem. First threshold problem. Did the Cold War politics violate the principles and purposes of international law, UN Charter? And did massive aid to military dictators who can fight communism a violation of international law? And if it was not, then how can you begin to recover debts or adjust debts today as if the past never happened? What's the causal chain of narrative? I have to finish, unfortunately, because we can have some time for discussion. And this is not in, this is a very sketchy presentation, forgive me, but it's best I can do. I want to go to the present situation. Now there is a Center for Social and Economic Human Rights, which in its report called Constitutionalizing Austerity has suggested how the European Structural Adjustment Program, what is it called? In German, Strukturwandel, structural transformation, I think, imposed on Europe and the southern European countries, violates the German state's obligations under the International Civil and Political Rights Covenant, under the Social and Economic and Cultural Rights Covenant, article by article, word by word, under the Women's Rights Convention, under the ILO conventions, and I can go on till the sacred cows can come home, but I won't. It's a wonderful report, it's available. What's the point? The point, and now of course, the treaty, I forget the name of the treaty, it's an extraordinary treaty in the history of humankind. Financial stabilization, something. What does it say? Those countries which claim and remain eligible for aid in the Eurozone crisis or financial monetary crisis are under a duty to rewrite their constitutions, to impose an austerity regime. Goodbye to human rights, which the European Court of Human Rights itself has developed. Goodbye. Now, I'm not an economist, I'm not speaking on that, I'm highlighting something that worries me. European finance stabilization mechanism, European financial stabilization mechanism, the European Central Bank, you name it and you have it. How far are these arrangements compatible with contemporary human rights standards? If they mark a recession of human rights, is there a way in which you can do these programs of monetary and fiscal discipline in a way that is more sensitive to human rights standards, which Europe quite rightly claims the authorship of worldwide, which Europe regards as its prized cultural export for the rest of the world, and again quite rightly. Is there a way of relating bailouts, structural adjustment, disciplinary globalization, regulatory Eurozone crisis in a more human rights oriented, sensitive, if not wholly friendly ways? Obviously, it is not the case. With this, I end finally. Please forgive me, I've been promising the end, but I'm always postponing it in a Derridian gesture of deferral. But I assure you now I'll end. And that is the... I'm not moving the slide, sorry. Grotius said a long time ago, there's a moral and some problem. Don't worry, poor man is great. Evolution, forget it. Structure. Here we go. This is the last point. Patrick O'Callaghan, in a recent article this year in Journal of Legal Studies, draws our attention to the fact that the German response to the Eurozone crisis is not merely conditioned but determined by cultural memory. And according to O'Callaghan, the cultural memory goes back to the standard historical narrative, and I quote, of the great inflation of Weimar Germany, which regards inflation with trauma and catastrophe. So I don't understand I don't claim to understand German history, but I think there's a point that is being made here. And he then goes on, and you can see that, he says what is happening in German approach to Eurozone crisis is, he draws our attention to two kinds of memory that George Bergson developed. One is habit memory or mnemonic memory, and the other is the imaginative memory. That is, memory is a work of imagination, not as a work of habit, which he calls pure memory. That is Bergsonian understanding. And in relation to the resistance of Germany leading the EU on the central bank as a lender, European Central Bank as a lender of last resort, he says this is an example of Bergsonian habitual memory. Now, in other words, there's no reflexivity into this, there's no recognition that the Weimar inflation times were important, they were catastrophic, they led to bad futures, But this is just what Bourdieu will call doxa, or habitus, to complicate matters. That kind of memory. Whereas what we need to do, he says, in response to the Eurozone crisis, and so the French think, so many other people think, is to broaden the horizon of understanding and get beyond mechanical memory and perform feats of pure memory. Therefore, speaking at the auspices of the great Institute of Lowest Culture, I want to assure Professor Gephardt that by these dreary details of sovereign debt, international or odious debts, I have not forgotten culture and memory. And in fact, it is a good example of making of regional financial law as culture torn asunder by these two types of memory. Thank you for the time being.